Hello, everyone, and welcome to this new episode of the Privacy Rules Privacy Espresso series. Today, I'm with Kelly Dickson, that is managing principal lawyer from the Australian law firm Macpherson Kelley. And today, we are going to discuss together about the recent half of the year report from the Australian Information Commissioner related to data breaches, so data breach report. And Kelly is going to provide us with some more insights on what does this report says and what we can learn from it in particular. So Kelly, I think we can immediately start on this. And can you tell us a bit more about the main highlights of this report?
Absolutely. So this is a report that is published every half year by our Federal Privacy Commissioner, the Office of the Australian Information Commissioner, or the OAIC, and it just reports on data breaches and the trends that we're seeing here in Australia. So in the last reporting period, the OAIC was notified of nearly 400 data breaches in Australia, and that was from January to June of this year. That's a little bit down on the previous reporting period. But 41% of the reports that were made to our authority were for cyber-related incidents, cyber security incidents. So ransomware, phishing, or stolen credentials, which then allow people to get into systems and access data. We also had, as I think a lot of our watchers and listeners would be aware, an increase in Australia in large-scale breaches. So these are data breaches that are affecting either multiple entities or lots of people. Think about Optus, think about Medibank, and a couple of those other ones that have happened here. So one of the other things as well that has been reported on in this report particularly was the speed of reports being made in Australia. So a lot of our watchers and listeners would know that under the GDPR, there is a very short time frame to notify of data breaches. In Australia, our Privacy Act requires an actual or a suspected data breach to be reported after an assessment has been done, and there's a reasonable period of time to do that. It's typically about 30 days. So unlike 72 hours, it's about 30 days. But about 70% of entities notified our authority within 30 days, and that is a decrease on previous reporting periods. So our commissioner is a little bit worried about the time that it is taking for businesses to report data breaches.
Got it. That's very interesting point and numbers, of course, that definitely provide information for careful consideration. Speaking about these, which are the real takeaways that we can take, in particular for businesses from this report?
Yeah, I think there's a few, and it's always useful to read this to see not only what the trends are that are happening in Australia, but also to see what our regulators' response is to that as well. So I think that the main takeaway is that businesses perhaps still aren't doing enough. So businesses need to have privacy and data protection and data handling practices in place, and especially need to have a data breach reporting mechanism in place. When a data breach occurs, as we know, there is so much going on. You're trying to work out what has happened. You can be dealing with customers who are very distressed and upset. And so having a proper system in place that you can then just put into action. Who do I need to help me? Who do I need to talk to? Who do I need to get onto my response plan is absolutely critical to help you detect the incident, to assess and respond to it, to report on it if you actually need to, and then all the way through to even recover from that data breach incident that is occurring. So get a data breach response mechanism in place. As I said, the OAIC is going to be focusing more on the time that it is taking in Australia for entities to detect a breach and to report on it. So I think that really businesses should be aiming to respond in a shorter period of time. And for those businesses that are global or who have, they're used to GDPR timeframes, I think that's helpful. to be able to respond to these things a little bit more quickly. I think that also one thing that hasn't been a focus for Australia very much, but should be, it's becoming a bigger issue, is probably two things. Firstly, whether a business really needs to actually collect the personal data in the first place when they're dealing with customers. And secondly, whether the business really actually needs to retain it. So I think that issues about data minimization and also data retention or destruction are really key issues that will come about in Australia further.
Perfect, Kelly. Thanks a lot for this. That sounds extremely interesting also because there are lots of connections with other regulations, as you were rightly highlighting. But of course, a data breach response mechanism is something that would be extremely important, not just to provide the information to the authority in due time, but also to data subjects and also to protect the information that the company has, because of course the quicker you react, the better in this kind of situation, at
And
least
you
to
often,
limit the damages.
yeah, you don't make good decisions when you're panicked about these
Exactly.
sorts of things.
And that's
Yeah.
something we learned with privacy rules, because as you perfectly know, as part of our team, we are working and creating this data breach mechanism. We have this data breach mechanism in order exactly to provide these kind of services, and of course acting preventively, having these in place before the breach happened makes a big difference, a huge difference, I would say, when there is an event like this to manage. So thanks a lot for underlining the relevance of acting quickly and being prepared to this situation. I just have a very last question for you that is more related to what's happening in Australia. Is there any other news, anything else that we should know?
Yes, I think one of the things that businesses all around the world need to be aware of for Australia is that we have current legislation before Parliament that is going to very significantly increase the penalties for privacy breaches in Australia. So at the moment, penalties are about $2.2 million for a serious and repeated interference with privacy. The proposal is to increase that to $50 million, 50, or 3 times the benefit that has been gained by the misuse of the data, or 30% of the company's adjusted turnover. So that is an extraordinary jump up in penalties. So that proposal is currently before our government. And aside with that as well, that same legislation is looking to give stronger information gathering powers to the OAIC. So it's really about strengthening the enforcement here. So I, of course, will let privacy rules and other people know when that legislation is passed, but we do expect it to be quite soon.
Okay, and that's definitely a good alert to receive for companies, because that's exactly in line with what we were saying before in getting prepared in order to respect deadlines and make the authority happy, in particular, in order to avoid sanctions, in particular if the sanctions are going to become so high as the one
So
you were
much bigger.
prospecting. Yeah. To us, and this probably is also aligned to one of our last Privacy Espresso, where we were saying that actually the Australian authorities are getting more and more close to other regulations in the privacy sector. It's interesting to say that they are even adding different layers of sanctions. And of course there is the willingness to have a regulation that can be really enforced through those kind of sanctions. So looking forward to know more about this. So please, Kelly, keep us updated as always. Thanks a lot for this. And thanks also to all our listeners for being with us today in this Privacy Espresso. So I really look forward to see you, Kelly, and our listeners in the next weeks, and in particular in the next Privacy Espresso next week. Thanks a lot to you and to everyone.